Hi everyone, Andrew Chamberlain here. Thank you for watching this video. It's a follow-up to my estate planning 101 video. I want to do something that is a little more advanced than the basic coverage of what should be included in your estate plan, which was what I covered in that video. You're talking about a main testamentary document, whether a will or a trust, a financial power of attorney, and at least on the healthcare directive side, a medical power of attorney or a living will. Now, this video, the 102, will cover FAQs I get frequently and perhaps a little bit higher level than those than the basic estate plan. So, this is high level, certainly not exhausted. There are many variations of estate plans and questions and documents and issues, but some things I hear about a little frequently is taxes. People have questions about death taxes, gift taxes. So, do I pay a tax if I give someone a gift? Do I pay a tax if I pass assets along when I die? Generally speaking, high level, the answer will likely be no. And the reason I can say that is that on the federal level, that has the estate and gift tax, you are exempt from paying any taxes for any gifts less than $12.92 million. So as we sit here, the vast majority of people don't have that amount of money or assets to give away. There's a lot to that. I can go on and on about it. Those numbers change. Generally, they go up with inflation, but in 2026, they're supposed to come down to about half that. But more common would be someone asked me, if I gave someone a gift, do I have to pay a tax? And the answer, once again, is going to be likely no. However, the caveat, and where people get a little confused about, is that if you give a gift over $17,000, you're supposed to file, or you must file a federal gift tax return. Basically, the government wants to track any gifts over $17,000. So when you die, they'll match that up with what you give at death. And if that number is over 12.92 million, you then pay a tax. If it's under, you don't. But for gifts, and then gifts under $17,000, you don't have to do anything, and you can give as many gifts under $17,000 to as many people as you want, and no one has to file anything. Hope that makes sense. Once again, I'll do more detail and cover this in more detail. Another common question would be, the will versus trust. Now, I mentioned it's important to have a main testamentary document. Just a note, you should always have a will, even if you have a living trust. And I'm going to do a ton of videos on wills and trusts, the ins and outs, etc. But, at the end of the day, there's a good chance you don't need a living trust, and a will is perfectly fine. This really has a lot to do with where you live. And note on the tax part, I was just talking about the federal taxes. States have their own taxes, whether it's an estate tax or a gift tax. Some states have an inheritance tax. The person who receives the gift, it gets taxed, like the lovely state of New Jersey, which is where I practice and reside in. So where you live really matters for taxes. So always talk to a local professional about that. And the same concept goes with should you have a will or a living trust. And you can boil this down in a simple form to, a living trust can help you avoid the probate process in your state. But the real question is, well, how difficult is that probate process in your state? And, if it's not, living trust is not just like a magic wand. You have to do some work with that, and you have to create it, you have to pay for it, which will usually be more than a will, and you have to fund it. So is that extra effort and money worth it to avoid the probate process in your state? Well, it depends on how difficult or expensive that is. And then also important to note, a lot of your assets will pass at death in other ways besides a living trust or a will. Classic example will be a pay on death in a life insurance policy. When you die, that policy pays that person, no court involved, and doesn't need to be a trust involved as well. So once again, I'll do a lot more on these. Asset protection. I'm getting a lot of calls about asset protection. Generally speaking, if you're working with an attorney, it's come in, two high-level ways. One would be the irrevocable trust, and I'll talk a little bit more about that. And then you can also form a corporate structure such as an LLC, and that's usually commonly done with like a rental property, for example, owned by an LLC, and that property is isolated if it's managed properly in the LLC, keeping it separate from your person. If there's an issue, that's the only asset someone can go after. And the irrevocable trust is essentially quite similar. Basically, with the irrevocable trust, you're giving up a certain amount of control of what that asset. And if you get sued, someone's coming after you for money. Well, you don't own that asset. It's owned by an irrevocable trust. So very basic, but asset protection, irrevocable trust, corporate structures, something I get questions on. I do elder law, so a lot of times we're working with an irrevocable trust and trying to protect someone's hard-earned money from the high costs of long-term care. Healthcare directives, beyond the two original essential ones I mentioned, the medical power of attorney and the living will. There's a bunch of others. One of them I get questions on are the do not resuscitate order, or a DNR. Generally speaking, you don't really want this unless you are really in a circumstance that you do not want to be resuscitated in any way, shape, or form, no matter what happens. So I don't know if you have, say, terminal cancer and you're thinking about this, but I don't know, you're choking on something, for example, and you could be easily, your airway could be cured. If a paramedic sees the DNR and they could save you, they're just not going to save you. So it's really meant for, extreme situations where people really do not want to be resuscitated in any way, shape, or form in any and all situations. Another one related to healthcare is, just side note, there's also something called the dementia directive. It's another healthcare directive, and some people execute this. I will include it in estate plan, saying basically, if I am in late stage dementia and things are really not looking good and I'm refusing to eat, essentially in this worst case scenario, some people don't want to be kept alive and spoon fed. And there's a little bit of conflict if you're in a facility, for example, which you'd likely be. You're paying a lot of money, and it's a bad situation, and the dementia directives gives a little clarity to the people taking care of you, kind of what you want in this worst case scenario. Another document that is not, it's, I don't know, not too common, I don't think, but I think it's a good one, is a final disposition memorandum. So final dispositions generally will be about designating the people to handle your remains and telling the world what you want to be done, buried, cremated, or if you paid for something already. So it's good information for people who are taking care of you after you passed away, and guidance for them and who's in charge and what you want. Usually this would be put in a will. However, the problem there is a will isn't valid until it goes through the court process. And a lot of times, that's going to take longer than, funeral and a ceremony after you pass away. So taking this out of the will and putting in a separate document, final disposition memorandum, for example, is generally a pretty good idea. Granted, things usually work out if people aren't fighting and your intentions are clear in your will. But there's always room for people to fight. So you want to keep it clean, keep it simple. Having a final disposition outside of the will is important. Once again, state specific. Not every state allows this. Some states just allow you to state this in your will, which doesn't quite make that much sense, but it is what it is. Power of attorney, covered in my other video. Extremely important document, and we can get in the weeds on the power of attorney. But one higher level concept is, should your power of attorney be springing, or should it be immediately effective once you sign it? Now, I always, or 90 whatever percent of the time, make it immediately effective because it's just cleaner, it's simpler, and at the end of the day, the most important thing, whether it's springing, and I'll explain that in a second, or immediately effective, is that you trust that your agent will do anything and everything in your best interest. They have a very high fiduciary standard to be acting in your best interest, and they can get in significant trouble if they're not. Some people want the springing out power of attorney, which kind of springs alive when you are incapacitated. And a lot of time for this to spring and work when you're incapacitated, the document requires a doctor to say that you are in fact incapacitated, and many times two doctors. Now, the problem with that is banks are generally, no offense banks, but can be very difficult to deal with. And if they see doctors involved, they might say, no, we don't want to deal with this document. Also, sometimes doctors could be hard to get in contact with, or might not want to be involved with this. So it's just cleaner, simpler to make it immediately effective. And once again, if you trust your agent completely, it's really not an issue. So hope that was helpful. Just a few more advanced concepts related to estate planning. There are a ton more. Do a lot of other videos. So if you found this helpful, please subscribe, give me a like, and have a good rest of the day. Thank you.